So today we're going to talk a little bit about raising capital and how to raise capital for a hotel deal. Now, this can apply to any traditional type of real estate transaction, but we're focused a little bit more on specifics for hotels with examples. So let me share my screen and then we'll get started. All right, so how do you raise capital in a hotel deal? Well, the first thing that you have to think about is, okay, what are some of the legal concerns that you have, not just business, but what are the legal issues in raising capital? First, we have to look at what are the different laws that apply. So you have the Securities Act of 1933. That deals with whether you have to register a security or find an exemption. The Exchange Act, two different sections that come up when you're raising capital. Investment Advisors Act, Investment Company Act, these are all federal laws. Then you have general corporate, tax, and state law compliance. So these are all, the reason I tell you this is there's all these different laws that apply on federal and state level that you have to look at when you're raising capital and structuring a deal. So generally, the first thing you have to think about, okay, what is the difference between a security offering or a partnership or joint venture? So on my YouTube channel, I talk a little bit more in more detail about the differences. So you can find more videos on that there and subscribe, Securities Law Media on YouTube. But the securities offering, a lot of times we'll have clients come in and they'll say, well, it's just a couple of us putting our money together. It's really just a partnership or a joint venture. So how do you know, is it really a securities offering where you have to worry about compliance, or is it just a joint venture or a partnership? So a security is basically very broadly defined by the SEC under federal law. It includes almost any type of investment, a note, stock, interest in an LLC, a limited partnership interest, a promissory note, an investment contract. And the most common term that you'll hear, especially more recently with crypto, whether crypto is a security, is the Howey test. And this came out of a case where basically the court said, if everyone pools their money into a common enterprise with the intent to make a profit based upon the efforts of someone else. In other words, you're basically passive in the deal and not running it. And that is a security if you're offering something like that. Partnership typically, or a joint venture, requires a more active participant or role. You're not just a passive investor. You're not a silent partner. You're actually managing the asset. You're somehow involved in running the company, running the business, some type of active role in the business, and not just more like an investor. And most deals that we see where people come in and they try to argue with me about it, but at the end of the day, most of the time it ends up being that it is a securities offering and not just a partnership or joint venture, just because you call it that or don't want to have to comply with securities law. It doesn't work that way. So who is making the investment make money? That's one of the primary concerns from the SEC's perspective, is who's in control. Like if it's a partnership, yeah, we put our money together, but who's really running the deal and who's active in turning whatever that is, a company, an asset, into a profit? Who's in charge of making money for it? So in a land development deal, you might be okay saying, okay, well, the person who's running the deal really has no control over appreciation of land. So maybe it is just a joint venture or partnership in some cases, but where there's an active role where, okay, I'm actually out getting entitlement and zoning for a land, and I'm going out and finding potential people to purchase the land or develop the land, or going out and finding contracts. So the people who are doing that are the ones who are actively trying to make a profit on that asset, and that is a securities offering. So if it is a security and a securities offering, it has to be registered with the SEC. And that basically means that you take the security and you file a bunch of statements with the SEC, typically starting with an S1 or a registration statement. And it's a very lengthy process. It has to get reviewed by the SEC. A lot of times you need audited financials. You really need, quality legal counsel, CPAs, auditors, just to get everything ready to file that and respond to the SEC. And it can take, 6 months, a year or more to actually register your stock. The other two things are exempt security or an exempt transaction. The most common that we deal with in private offerings is number 3, an exempt transaction. So what are the most common exemptions Regulation D, Reg D, that's what you'll hear. And based on statistics, over the last 20, 30 years, 70, 80, 90%, I would say at least 70 to 80% of private offerings to raise capital fall under Regulation D as an exemption. That means it's number 3, exempt transaction for this capital raise, and you don't have to register it with the SEC, and you can still be compliant. The most common rules underneath Regulation D that you'll hear about is Rule 506B and Rule 506C. Rule 506B is probably the most common one that people use. And this says that you can raise capital, however much capital you want to raise. You can't go out and advertise or generally solicit, but you can take as many accredited investors, and there is a definition in the SEC on what's accredited. The most common that you'll hear is someone who makes over $200,000 a year, or $300,000 with their spouse, or has over $1 million in net worth, not including the value of their home. You can take as many of those as you want. Now, if they don't rise to the level of accredited, you can still take up to 35 not accredited, but they still have to be sophisticated. So here's the definition of sophisticated. It's not a hard objective test where you can look at a tax return and tell, but they have to have some general knowledge and experience in financial and business matters, so they can basically understand the risks of the investment and make a good decision on whether they should invest and can afford to lose potentially their money in making this investment. Now, 506C allows only accredited investors, so you can't have any of the lower level sophisticated. Everyone has to be accredited. Plus, you have to also go through and independently verify that they are accredited. That means getting backup documents or a letter from their CPA that says and verifies, yes, these are my clients, and I verify that they are accredited, they meet the test, because I do their tax returns or whatever it says. But the benefit of 506C is that you can go out and advertise, you can post it on social media, you can put it on your website, you can go out and pitch this deal to just about anyone. So that is the benefit, but the limit has to be accredited investors, and you have to independently verify them. Now, with 506B, there's a little confusion over what is, general solicitation is not allowed under the first one, 506B. What does that mean? I also have a little bit more detailed video on this on my YouTube channel, but essentially, general solicitation, you have to have a pre-existing relationship with that potential investor, and pre-existing meaning I had to know them before I came up with this deal. So you had to already know them, and it had to be in a substantive relationship. What the SEC looks at is the quality of that relationship. Okay, our kids go to school together. I've known them for 5 years. Okay, it's pre-existing, but how substantive of a relationship is that? If it's a matter of, okay, well, our kids go to school together, but I know what kind of car they drive, that's not enough. You need to know a little bit about their investing, financial background, like if you know what they do for a living, if you've heard them talk about, or that they're involved in other investments. You have to have some kind of discussion or understanding that they understand the risks of the investment you're going to put in front of them. Then you can have a pre-existing substantive relationship, and it's not considered general solicitation. Anything outside of that is a problem, and you have to look to 506C typically, where you have to only go to accredited investors. And this is where you hear about people talk about, oh, well, I have a friend of a friend, maybe they can invest. You probably don't have that pre-existing substantive relationship with a friend of a friend, because it's somebody probably that was just referred in that you've never met and you don't know anything about. So that's probably a general solicitation that's not allowed under 506B, but you could do it under 506C. Now, what are the consequences if we don't follow the rules? Okay, well, yeah, that sounds great. It's a securities offering, but that sounds like extra money and hassle. Let's not do that. What are the consequences? So there are risks involved, and it's a matter of looking at what are the risks if you don't follow the rules for a securities offering. The SEC is the primary agency that would look to regulate on a federal level any potential violation, and it would be an unregistered sale of security if you don't follow the rules. If you don't follow an exemption, they could technically go after you, basically sue you for unregistered sale of securities. Each state has their own regulatory securities agency. And each state, if you have an investor or the deal is located in a certain state, that regulatory agency also could come after you with some kind of regulatory action, depending on what that state has in place. If they do that, one of the most common things that they'll look at is what's called rescission rights and disgorgement of profits. So if you had a deal that was 6 months ago and they come to you and say, this was unregistered, so you need to go in and you need to offer to rescind or basically take back their investment, give them all their money back plus interest, and any profits, disgorgement of profits, any profit you got by using their money, and give that back to them. They don't have to take it, but you have to offer it to all your investors and say, hey, I will give you back all of your money plus interest plus a percentage of any profit I got. And you have 30 days, 60 days to decide. If you don't want to accept that offer, you stay in the deal, you stay a shareholder, everything goes on. If they elect to take it, you got to come up with the money to pay them back. They also can impose things like fines, penalties, and something that can have significance is an injunction that prohibits you from relying on any exemptions. So they could say, you can no longer rely on Reg D ever again in the rest of your life. So you can no longer be involved in any way in a securities offering. Sometimes that falls under what's called a bad actor disqualification under Rule 506D. And if that happens, you can no longer be a GP, executive officer, manager, director, anyone in any role of a company that's raising capital in the future, ever. So some people, I don't have to do new deals in the future. But it also says that if you own 20% or more as a beneficial owner, you're also precluded. So you can no longer invest in other deals if it's going to be more than 20% in their deal because you're disqualified as a so-called bad actor. So it can have some significance. It doesn't happen all the time, but they are able to do that, make that kind of a prohibition to where you could potentially be excluded from being involved in any kind of deal going forward. And that's any kind of private placement, whether it's real estate or investing in a private hedge fund or anything like that. The other thing that can be really big is private investor lawsuits. When clients come to me, they say, oh no, everything's great. We're all buddies. Everything's great. Well, have you prepared for a business divorce? Because when things go south in business, it can get just as nasty as a divorce. So think about, okay, you have a great hotel deal and COVID hits. Then suddenly, all right, well, the property is basically shut down. And so there's no cash flow. We're filing bankruptcy or we're selling it, we're foreclosing, giving it back to the bank. Suddenly all the investors that put their money into that deal probably aren't going to get anything back. They've probably lost all their money. At that point, they're not your buddy anymore. And so now they're going to be looking to come after you in a private investor lawsuit and sue you. One of the claims that they can bring is if you did not follow the rules as a securities offering, they can then say, okay, well, you didn't follow the rules. This was an unregistered sale of securities. Therefore, under either state or federal law, I am opting into my rescission rights, the one that I talked about before. Now I want all my money back, plus interest, plus potentially disgorgement of profits or anything else, any other money that they might be owed. And oh, by the way, I'm going to sue for this. And once I have a judgment, you're going to be personally responsible. And maybe you have 30 days to pay, whatever it is, depending on how it shakes out. So that can be a huge potential risk of not complying. And it's not that hard to comply. So, when you look at what is the risk versus the reward of paying some legal fees and going through the process of making a securities offering, it's not really that complicated. versus potential investor lawsuits that will come after you personally for hundreds of thousands, if not millions of dollars down the road, and they have the right to do so if you didn't do it right. Criminal proceedings, that's pretty rare. You'll see that'll pop up in the news where the Department of Justice goes after someone for securities fraud or something like that. And it also involved an unregistered sale of security. Potentially there is, you could face a criminal proceeding and jail time or fines. It's pretty rare in that context, but it can happen. So when you're raising money for any kind of a hotel deal or any kind of real estate deal, you'll hear the word syndication. So syndication is basically pooling capital to put into a real estate deal. It's an investment in a single asset versus a fund where a fund might go after multiple assets. So it's investing in a single asset, pooling cash from investors, putting all of our money together to put a down payment, put the equity in, pay for construction, working capital, whatever it is. If there's a property improvement plan, a PIP, they might go towards that. And that's what it's used for. It's led by somebody called a sponsor who typically sources or finds the deal. So they find this, hotel that's over here that is underperforming because of COVID, but it could be turned around with some basic improvements, marketing, whatever it is that needs to be done. So the sponsor comes in, finds the deal, manages the asset to bring up the value. And in a syndication, you'll know which asset you're specifically buying because it'll be disclosed that, okay, here's the exact property we're going after. There's a set return, any fees that are disclosed for the sponsor for putting the deal together, and you'll get a general idea of your payout timeline. This is an org chart of a typical real estate syndication. On the top is the hotel. Let's say you're acquiring a hotel ABC, that's the asset. Underneath that is what's called the issuer. That's the company that is basically usually an LLC or a limited partnership. And that's where the investor capital goes. That's the borrower on a loan. That's going to be the owner of the property. Then underneath that, the owner of that issuer is the members who are investors, Class A members. Maybe they own 80%, whatever the numbers work out to. They own a certain percentage, and then usually we'll set up a separate manager LLC, which is usually a Class B member. And let's say it's an 80-20 split where they get a 20% profit or promote. And so the LLC gets 20%, the investors pro rata get 80% of any profit from cash flow or from the sale. And then underneath that, the manager entity is usually owned by the sponsors so that when they get paid out, it flows through their LLC down to them. And that provides some liability protection, and it mirrors what a traditional, if you use an LLC, it still mirrors what a traditional LP-GP structure is, where your Class A members are like an LP, Class B member and manager is like the GP with a separate LLC. So it's a similar type of structure, even if you use a limited partnership. This is the cash flow in the same org chart I just showed. Your investor capital on the right goes up. They put their money into the company. They get a profit distribution of 80%. And if there's a preferred return or anything else, that goes down to them. The rest goes down, plus any asset management fees or anything else, down to the manager, and then it flows through down to the sponsors, depending on how it's structured. Now, if it's typically a partnership or joint venture, usually there'll be an LLC formed that will be sort of the joint venture LLC or partnership LLC, and that will be the owner, the acquirer of the property, Hotel ABC. And then underneath you have all the different partners, and maybe there's 4 partners equal 25% each. So they put their capital into the partnership, and then the partnership pays out their 25% upon distribution. And like I mentioned earlier, partnership or joint venture, it's very restrictive that a partnership has to really be a true partnership or joint venture. You have to all be actively involved in management and control of the asset. Otherwise, it's most likely a securities offering, and you would not be able to do it this way. Now, question that we get asked, it's more on the business side, but it also involves legal. How do you go out and raise capital? Let's say I've got a potential hotel deal. I'm based in Dallas, so let's say it's in South Lake or it's in Highland Park. There's not a lot of hotels in Highland Park, but let's say it's in downtown Dallas or South Lake or Fort Worth or somewhere. Okay, so now what do I do next? How do I raise capital? One of the first things you need to look at is kind of a model, a basic executive summary, business plan, pro formas. Start to create sort of a pitch deck for your investors. This is a high level summary of, okay, what is this deal all about? What are the financials? Kind of give me a high level look at, from 50,000 feet, what is this deal all about? Pitch deck can be, usually they're like 4 to 15 pages, not too lengthy, that you could put it into like a webinar or make it easy for someone to digest what you're doing. Usually it's going to cover things like, okay, what is the deal? Okay, it's this hotel in South Lake that we're acquiring. It's underperforming, and we basically need to increase occupancy and do some investments into renovations or something. And we think that because of that, we're going to increase revenue, bring it to where it should be, and start to profit, and 3 years sell it, something like that. You also want to explain, who are we? Like, who am I? What's my track record? What's my experience? Why should you go with me to run this deal? And usually that's your bio, your resume, like your track record, what you've done before, and why they should rely on you to manage this deal. Same thing, why us? Why this deal? Is this deal better because the market that it's in, it's underperforming? And here's the statistics of how it's underperforming in the market that it's in geographically. What makes this deal unique or attractive to an investor? What are the returns you're offering? So a lot of investors come to us, or I'm sorry, a lot of sponsors come to us who maybe are newer and, oh, I found a great deal. It's going to make a ton of money. I already know I've got an LOI on it and it's all locked up. I'm already talking to a lender. Okay, well, what are you going to offer to your investors to basically bring them in so where they'll write you a check? And a lot of people haven't really thought through this very well when they come to me, which is kind of surprising. But if you do a financial modeling of it, you need to figure out, what are you going to pay out your investors? Because something can look profitable, but if you start offering a 12% preferred return plus an 80-20 split, and all the expenses of renovation and your loan might adjust up an interest rate, like there's so many variables, you need to model this out and say, what can I afford to give investors and to make it attractive to them? Current market on preferred returns, depending on the type of asset, you could be looking at 15% preferred return plus return of capital and a profit split. So every year they're accruing, even if it's low, even if it's 6%, every year they're accruing 6% on their money. You're going to have to pay them back 8% on their money, 10% on their money. Maybe there is no preferred return, but those are pretty common right now. So how are you going to be able to pay that back within your budget? Is that actually still going to be profitable? What's your operating plan? What's your exit plan? We plan to finish renovations year 1, and by the end of year 3, we'll be fully, at the current occupancy that we need, cash flowing positive. Here's our pro forma projections. Year 4 to 5, we're going to market and sell it. Here's our projected, future value that we're going to sell it for, and what we're going to distribute to our potential investors. Then once you've got a general concept of this, then you come to someone like me, as a syndication attorney, securities attorney. We set up the legal structure, and you also need to start thinking about, where am I going to find these investors? Because that's going to play into securities exemptions and some other factors. So you need to figure out, what type of investors am I going after? Where am I going to find them? And in terms of the legal structure, that was the org chart that I showed you. So we have to file to form the different LLCs. They all need operating agreements. You have a subscription agreement, which is what your investors sign. It's basically saying, hey, I'm agreeing to put my money in and get 100 units or 100 shares or 10% of this deal in exchange for my $100,000. Here are the terms I've agreed to. It's a contract with your investor. You also usually have a questionnaire of some sort, collecting some basic information from them. Potentially, if it's a 506B where they might be sophisticated and not accredited, you want to collect more information to determine and prove that, yes, they said they were sophisticated because here's all the deals they've invested in the past. They have this brokerage account, they have this, they have that. So they understand what they're doing. Then a PPM is the private placement memorandum. And this is your disclosure document. This is something that would be disclosed. It's not given to the SEC unless there's like an enforcement or an investigation, and also if there's a investor lawsuit. This is something that is given out to people before they invest. So you want to give that to them ahead of time. And a PPM is basically an expanded business plan with all of the risk disclosures in there. So it's going to tell you all the things about securities law disclosures. These are restricted stock that you're buying. You're not going to be able to transfer it. You're not going to be able to sell it. There's no market for this. Here's all the risks involved in investing. So, okay, well, the market could go down. We could have another pandemic and hotels shut down. So all of a sudden our operating cash flow goes away and we lose the deal. We have to file bankruptcy. We're relying on only a few individuals to manage this deal. What happens if they die? Just all these different potential risks of investing that you're disclosing to your investor so that they can make a full and fair informed decision. That's one of the things the SEC cares about. They don't just think caveat emptor, the buyer beware, just watch out for yourself. No, they're a regulatory agency that is out there to basically protect investors and make sure you get full, fair, transparent disclosure. So that's what the PPM is. It might have your pro forma projections. It might have your pitch deck. It's got a bio of you. It's got the deal, what the offering is. Okay, we're giving you a 12% preferred return in exchange for your 100,000. Here's what you get. Has all the very specific items that you're getting for your money, and how returns are going to be figured out, distribution waterfalls. All these things are covered in the PPM and the operating agreements, so your investors know ahead of time what they're signing up for before they sign a subscription agreement. And that is key. PPM and all disclosures should be provided, and the SEC says a reasonable time. So a reasonable time prior to their investment. So that doesn't mean pitch your investors, get a soft commitment, rush to get a PPM done, and send it to them the same day that they sign the subscription agreement. No, you need to give them enough time to read through what is usually 60, 70, 80-page document. So at least a few days ahead of time. I recommend at least 48 hours, if not more, so that they've had enough time to potentially look through and ask any questions that they may have of you before they sign a subscription agreement. So I would distribute a PPM, at least 3, 4, 5 days ahead of time, have proof you delivered it to them. And then whether you use a portal software that delivers investor materials to them and can track that, some way of tracking when you sent it to them, and then send them subscription agreement, DocuSign, whatever it is, 5 days later, 3 days later. And so they can sign it then if they choose to invest. So you also have to depend, like when I said decide where to find investors, if you're going to be going online, you don't have enough pool of investors. You're going to have to go out to extended networks. You might have to do road shows. You might have to put this on social media. Then you need to figure that out ahead of time, because we have to decide if you're going to use 506C or 506B when we put together all of the documents in the legal structure. Also need to think about administration, because basically you are dealing with people's money, investor relations. There's a lot of good portals that you can sign up for as a service. They will deal with K1 distributions, investor reports, providing those to all your investors, collecting subscription agreements, just general investor related issues. There are software you can use to do that. at varying levels of cost versus having to email everyone yourself and respond to 200 investors yourself. Accounting, tax, or CPA is always key too. They're going to be preparing your K-1 distributions every year, and you want them involved in making sure your structure is right, your tax allocations are right in the operating agreements, and that you're following the letter of what you're giving your investors. And securities filings. So we have a Form D under Regulation D that we have to file with the SEC within 15 days of the first sale of a security. So when you first start bringing that money in, depending on a number of factors, we look at, when is the first sale of a security? 15 days after that, okay, now we have to file the Form D within that 15 days. And it's typically the same with what's called blue sky filings, which are state law filings that have to be done where your investors are located. So if you bring in investors from 4 different states, we have to look at all 4 states and see whether we need to file a notice filing in each of those states. And there's usually filing fees in each of those states too. The federal Form D, there's no fee. Each state has their own filing fee. So some states have none. Some states are more expensive than others. So once we know where your investors are, we plug that in and we can say, okay, you're going to owe $300 in blue skies or $5,000. Like, for example, if you have investors in 49 states, you're probably looking at close to $10,000 in blue sky filing fees that are just to file those, paid to each state. On average, I would say most of our deals, blue skies, are $2,000 to $3,000 with a few states involved. Now, who are you going to pitch this to? You really have to know your audience. So is this just a group of friends that you know really well? They understand, like they're all hotel owners and they all invest in hotels. Okay, that's a different audience than if you're going out on a retail market, putting this online to just the average Joe that might be looking to put money in. Even if they're accredited, they're still a different audience. What is the type of investor? Where are they located? What's their background? You've got here's some examples of potential investors. Most of the time, you're not looking at institutional unless it's a very large deal, but these are your large financial institutions who have separate sectors set up for the intentional investments into, let's say, hospitality. They have a hospitality arm. They have a fund that invests only in hospitality. There's a large family office that invests only in hospitality. Private equity, venture capital, that's usually not typically real estate deals that you'll see, but that is one type of investor audience, and they are looking for a very different type of deal on control, on returns, all of that. Angels or high net worth individuals, they are, that's going to be a different type. They're usually sophisticated, accredited investors. They understand, but again, you're dealing with individuals. Family and friends, small, close network. Those might be kind of angel investors, but I put those in here separately because most people call them family and friends. It's, local, close people in some type of tight-knit community. So you have to figure out who you're pitching this to make sure you tailor it to them. Retail, this is more if you're going to put it on a sort of a website that distributes it for you. There's a number of them out there where you upload your offer, usually a 506c because it can be publicly offered, and then they distribute it to all of their members. And these are more your, one-off John Smith that you don't even know, but it's a retail, quote, retail investor. Also, if you advertise on social media, that would be kind of more of a retail investor. How do you pitch? Well, I can't tell you exactly how to pitch a deal. You can watch a bunch of episodes of Shark Tank to watch how people pitch, but what you need to know is you need to know the current market terms. You need to know your deal inside and out and the current market, competition, all the pros and cons. Know your market terms. Okay, what are investors looking for these days? 2 years ago, or even a year ago, was very different. You might not have to offer a preferred return. Now, maybe you have to offer 6%, maybe 8, 10, 12, 15. I've seen 22%. 20% preferred return plus an 80% split of profit. What is it? We got to figure this out ahead of time, because you want to make it attractive to your investors, but also and compete with the market, but also understand your pro forma projections, financial modeling, underwriting of the deal, so that if you can actually afford this and make it profitable with a good return. Think about possible questions. It's surprising that people don't sit back and think about it. They get all hyped up about a deal, how great it is, but take a break, set it to the side, and come back and say, if I was an investor and this was $1 million of my money that I was going to put into this deal, and I didn't really know anything about it, what questions would I have? Think about it, put yourself in that position and say, okay, if I was putting $1 million into a hotel deal in a market I've never been in, what are the questions I would want to know? And think through all those and come up with the frequently asked questions in your pitch deck, because you will get a lot of frequently asked questions, and just know those ahead of time. Like, okay, I know people are going to probably ask, whatever it is about the current market. Okay, are you still seeing a recovery from COVID? What happens if, interest rates go up? What happens if interest rates drop? What happens if there's another pandemic and another shutdown? Have you thought about these things? Have you modeled them? Can't control everything, but at least your investors understand that you've done your homework and you've thought through all the potential issues. Brings me to my next point: disclose all the risk and all the negatives. And people don't want to hear that from me when they're out pitching a deal, and they look through a PPM and half of it is 40 pages or 20 pages of risk factors why you should not invest in this deal and you're going to lose all your money. That's my job. Like, I want to disclose all of that to your investors, but don't just leave it up to me. When you're talking with your investors, they're thinking about the risks in their head. So don't avoid them. Think about the pros and the cons. Like, okay, we understand that the market here, or we're going to have to put in a significant construction period and it's going to take time for this. And, here's some variables we don't know. Here's some potential risks that we have. Permits are going to take longer than expected. All these things, make sure you've covered those. And it's better to bring up some of the like, if there's a huge red flag and you just avoid it and just don't talk about it, that's a problem. Like, if there's a red flag and you know it, talk about it, bring it up. Your investors will feel a lot better about it, that you just didn't like brush over, say, oh, well, no, we figured that out. That's not a big deal. No, you need to say, yes, we understand there is a potential issue with this. And here's how we're going to potentially deal with it. There's a risk here. There's a risk there. If this happens, this is what we will do. If this happens, this is what we will do. If interest rates continue to go up, we have a rate cap. We have a different lender. We have a bridge loan. We understand we have to refinance within 2 years. Here's our plan. Come up with all of those potential issues and talk about them ahead of time. And that comes to pro forma projections, modeling best and worst case scenarios. So don't just do pie in the sky to your investors that this is going to be the next $100 billion deal. And they've never, you're never going to be so rich as when you invested in this deal. Like, that's not realistic. So look at your best and worst case in your pro formas and even disclose those. Like, do a spreadsheet that says, okay, here's our target, here's worst case, here's best case, so that they can look and see, okay, well, here's what they're targeting, but if things go bad, what's the worst case? Okay, I'll get all my money back, or I'll get 80% of my money back, or I'll get a 10% return, whatever it is. And this is sort of goes without saying, have a good deal that shows good returns and sponsors who care. That can make a huge difference in my experience. So right now, especially since deals are limited, everyone's looking for a great deal, but you can find investors. If you have a great deal, it's easy to find investors. Like, if you say, okay, I have a deal where it's guaranteed that if you put $50,000 in today, in 3 days, I have somebody to buy this at double the price, and I'm going to give you a 30% return. on your money within 4 days, and there's some kind of contract in place and protection, and those kind of deals where it is almost guaranteed, or it's a very good deal, it's easy to find an investor for that. People can come up with money for that. And showing that you're someone who actually cares can go a long way, because even in the current market, we have existing clients who have deals that may have gone partially south based on interest rates going way up or insurance costs going way up. They are putting their own money in, even if they don't have to keep deals alive. So you don't have to promise that, but if people feel like they can trust you and know that you're that type of person that even if the deal's going south, you're going to put up your own money to make sure that the deal flows, then people feel a lot more comfortable with that. And along with that goes information. I can't stress how important that is, that being honest and open and transparent is not just protects you securities wise and also investor lawsuit wise, but it also helps with dealing with potential issues with investors. If you're open and upfront with them, it's amazing how many people who probably would have run straight to file some kind of complaint and file a lawsuit are like, okay, well, they told me there could be a potential issue. They're trying to figure it out. Here's how they're trying to figure it out. People are a lot more forgiving when you are open and transparent with them. There's even a recent case I did a post about where a company was doing well for 10 years. And this is not a hotel deal, but it's just an operating company in the real estate software industry, doing well for about 10 years. I think they were based in California, and they had started facing some financial issues. And the management, CEOs, top people basically started falsifying records and showing the board of directors, showing investors that they were still doing okay cash flow wise. Then they went out and raised money and showed the investors fake audit reports that they had doctored, fake, I think there was fake financial statements to make it look like they had more cash in the bank than they did. All these things where, and eventually the company, this all came out. They basically were fired immediately. The SEC has filed charges against them for securities fraud. They might face criminal charges as well. And all because they hid this, not because the business didn't do well. The business went into bankruptcy. 1,000 people lost their job. It would have happened a few months earlier. That's it. If they would have been honest and said, hey, we're facing a problem here, and these investors didn't put their money in, maybe they would have filed bankruptcy 3 months earlier. But these two people would not be facing maybe potential jail time and someone coming after them for millions of dollars for securities fraud, just by being open and honest and transparent. What are some of the key areas to look for when, whether it's a pitch deck, you're talking to investors, or your private placement memorandum, any of that? What things do you have to worry about? I've broken up into 4 main categories where I see sort of the most SEC complaints or issues come up: lawsuits, disclosure and compliance, false or misleading offering material. It's not even just about outright lying. Obviously, that's not okay. Making statements that are not based on any fact. Well, I know that this property is going to go up 20% in value in a year. Don't make those kind of statements because you don't know that. Also, misleading can be not saying something that you should. Oh, our underwriting and these projections that we have, they're based on certain assumptions. Maybe the assumption is, okay, well, look at this return we're going to get. This is amazing. Okay, well, oh, by the way, we used an assumption that in at the next meeting of the Fed, they're going to drop interest rates to 2%. They're going to go more than half of where they are now, and they're just going to drop interest rates, and it's going to cause all these different changes to where we're super profitable. You need to disclose that kind of an assumption, because without that, that has a huge impact on an investor making a fully informed decision if they look at a projection versus an unrealistic assumption that went into it that you should have disclosed. So something that underlies your assumptions, of your projections, you need to disclose that kind of stuff, because that could be misleading to an investor if you didn't tell them, oh, by the way, we kind of assumed that we're going to get to 100% occupancy and interest rates will drop in half. Also, if you, I mean, we had already talked about this, but avoiding it being considered a security by saying it's a joint venture or a partnership, or the broker exemption or registration. Basically, that comes down to finders. So, and I don't know if I covered this. Yeah, I covered it in the next one. Fees, unregistered broker being paid fees and also not disclosing. So normally you want to disclose any potential fees, conflicts of interest, and what are called related party transactions. So that means if I'm putting a deal together and I own a property management company that specializes in hotels, I'm 100% owner, and we're going to buy this hotel, and my company is going to be the new property manager. And we're going to be charging 5% instead of the 3% you guys were paying. Well, not only should we disclose we're increasing the property management fee from 3% to 5% per month, but also I own that company, so any profit is going to go to me. And that's a related party transaction that needs to be disclosed about the fee and the potential conflict of interest. It's not that you can't do it, but you need to disclose it to your investors so they understand. Then they can make it before they invest. Then they can make a decision, yes, I want to invest, or no, I don't. Using finders is not a good idea. So anyone who says, I'm going to bring in $1 million and you cut me a check for 10%, $100,000 the day they fund their money, and we're good. That's a problem unless they're a registered broker of securities, because that's something you need a qualification license for. So if they're not a registered broker dealer of securities, they cannot be out essentially selling your security, because that's not allowed. It's not allowed by law to pay them based on a percentage of money raised. Also, there's a problem with people that you don't have control over. You don't know what they told the investors or guaranteed them. That can be an issue too. That even if you don't give them a fee up front, maybe they made some promises or, oversold your deal to someone, and that's going to come back and bite you. Execution and information. I kind of covered this a little bit before, but making sure you're always updating your investors, especially if your business plan has changed. Your PPM executive summary may have said, here is our 3-year plan, or here's our 5-year plan. If that changes, especially within the last few years, with interest rates, the market, insurance costs, all these things that have affected real estate, keeping your investors updated, like, hey, by the way, we know, inflation is out of control and interest rates have skyrocketed. Here's how it affects us, and here's how our plan has changed from what we originally told you. Making sure you keep them informed. And when I say execution, obviously you can't control the results, but following what you said you were going to do. So if you said, I'm going to use $2 million for a property improvement plan, and you don't do that, PIP, you just use that money for general construction, build a separate pool, a new pool or something onto the hotel, or it's even worse, where I'll get into the next section, where you don't use it for this project, use it for something else. But following through on what you said you were going to do in your plan, you don't have to follow everything exact, but if you told investors one thing and you do something completely different, like you suddenly decide to buy a different property in another state, that's a problem. So you need to follow through on what you told your investors. Misappropriation. So misappropriation can be a huge issue and that comes down to the use of proceeds that you told your investors. You may have told your investors that I'm going to use, $500,000 for working capital. Well, turns out you didn't really need that much for working capital. So you figure, well, hey, I can get a 10% ownership deal in this hotel over in Arkansas. So I'm going to take this investor money. I'm going to buy a 10% interest in this hotel deal over here. without disclosing it to my investors that I'm not using it for working capital. So the investors now suddenly own, through the LLC, a 10% ownership in another hotel they didn't even know about. It's not that you're stealing their money. Obviously, if you use their money to pay your personal bills, that's even worse. But it's just you're not following through with what was disclosed to your investors, and that can be a problem. Also, your attorney set up your exemptions under the Investment Company Act, Investment Advisors Act, Securities Act, based on your plan that you had at the time. When you start varying from that, like you suddenly take $2 million that you have sitting around, you start investing into a hedge fund or buying and selling securities as a day trader or something. And even if you make the fund, like the LLC itself, money by doing that, you potentially blew an exemption under Investment Company Act. I mean, there's a number of things that can come into play that as soon as you veer off path, it might not be the way that everything was structured for you. So those are some of the issues in and how to raise capital for. Now, I've talked about hotel deals, but this is something that you can use for any real estate type of deal. It's basically raising capital for a specific project. That's what I'm talking about. And so you can apply this to a hotel deal, land development, multifamily, whatever it is. Some of the same principles still apply. Feel free to subscribe to my YouTube channel. I've got tons of free videos on there talking about a lot of these topics in more depth. And feel free to reach out. We handle cases all over the US and can help you with raising your capital. Thanks for watching.